You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Welcome, listeners, to another episode of People, Places, Planet. I'm your host, Sebastian Duque Rios, and today I'm excited to continue our Explain series where we're breaking down the United States' fundamental environmental laws. Today, we'll be talking about the Federal Insecticide, Fungicide, and Rodenticide Act, and I'd love to welcome our wonderful guest, Dr. Jennifer Sass, Senior Scientist at the Natural Resources Defense Council, and Keith Matthews, Principal at Matthews Law, LLC. Welcome to the podcast, y'all.
Thank you.
Yeah, thank you. Good morning.
Why don't you go ahead and briefly introduce yourselves and your connection to FIFRA and this work?
Sure, I can go first. I'm Jen Sass, and I've been at NRDC as a scientist and a senior scientist for about 25 years now. Since 2001, my postdoctoral research was environmental health and toxicology, and my doctorate was all in basic medical research. So my real background is in human health and how the human body works, and then how pollutants and chemicals might interact with that. Since being at NRDC for the last 25 years, I've brought that knowledge to looking at environmental laws. I work on toxic chemicals there and look at how they're being regulated by EPA and the science about them, whether it's pesticides or other industrial chemicals. So be it FIFRA, Clean Air Act, Clean Water Act, Safe Drinking Water Act, I've worked in all of those structures, but focusing on the human health concerns with chemical pollutants and potential human exposures.
I am Keith Matthews. I've been properly referred to as a chemicals regulation lawyer. I've been involved in the U.S. regulation of chemicals since approximately 1994 or so, with a very heavy concentration in FIFRA. I have experience in both the private sector, working at law firms up until 1996, when I then went to EPA, joined the Office of General Counsel, was an attorney at EPA, focusing initially, interestingly enough, primarily on the regulation of radioactive waste storage by the Department of Energy, but subsequently was able to move over and focus more specifically on pesticides, primarily working with BPPD, the Biopesticides and Pollution Prevention Division at EPA, and did that for about 9 years, and then actually went over to BPPD as the director. Rather than just providing legal advice and guidance, I actually was responsible for the implementation of FIFRA as it relates to biopesticides, and did that for 4 years, and then left EPA to go back into the private sector and started Matthews Law LLC about a year and a half ago.
Thank you both again so much for joining me today. And to get us started, I was wondering if one of you can give us a quick primer on FIFRA. Why exactly was it created, and what's some of the history behind it?
Yeah, I'm happy to do that. So FIFRA is an interesting statute. It has a longer history than I think sometimes people realize. The first iteration of what became FIFRA was the Insecticide Act of 1910. And it was more or less a consumer protection standard. And it focused on prohibiting the sale of fraudulently labeled, what were then called economic poisons. It was not regulatory at all. There was no standards for pesticides. There were no registration requirements. It was entirely marketing and, again, focused on fraudulent products. The FIFRA itself was then enacted initially in 1947. USDA, the United States Department of Agriculture, was given a responsibility for implementing this statute. It, again, was not so much a regulatory statute at that time as a marketing statute. It established labeling requirements and mandated that USDA register, and I put that in quotes, pesticides sold in interstate commerce. This wasn't registration or regulation on the basis of health and safety, but just making sure that individuals who wanted to purchase pesticides could know that the products that they were buying were at least identified by USDA. Now, interestingly enough, there were amendments to FIFRA in 1959. And the 1959 amendments are very critical in that they expanded the definition of pesticide in FIFRA so that pesticides were defined not only as substances that prevent, destroy, repel, or mitigate pests, but those amendments added the category of plant growth regulators to the FIFRA definition of pesticides. And so any substance that impacts, alters the rate of growth, the rate of maturation, or the physiology of a plant is regulated in the United States as a pesticide. And that's very unusual. No other country or regulatory system in the world regulates plant growth regulators as a pesticide. There were additional amendments to FIFRA in 1972. So 1970, EPA was created, brought into effect by President Richard Nixon, and the regulation of pesticides was then transferred from USDA to EPA, beginning the process of FIFRA becoming a more health and safety regulatory statute. A lot of this started with the realization in the 1960s that the environment is important. With respect to pesticides, of course, it was Rachel Carson. And Rachel Carson pointed out how there are very real ecological impacts to use of pesticides. Pesticides are intended to have adverse effects on living organisms, specifically certain living organisms, but chemicals don't discriminate. And so there came a realization that we had to pay more attention to the effects of these chemicals on non-target organisms. How can these chemicals be used in a manner that is safe or that doesn't result in significant adverse effects? So that's the big motivating factor for the changeover in 1972 to make FIFRA a truly regulatory statute. The 1972 amendments, known as FEPCA, established the familiar regulatory scheme that we know of today, whereby there's the FIFRA safety standards, no unreasonable adverse effects, requirements such as adverse reporting requirements under FIFRA Section 6A2, and the authorization for EPA to promulgate specific data requirements that must be satisfied for a applicant to qualify for a FIFRA registration. The last major change that I'll mention now is the beginning of what's called the Pesticide Registration Improvement Act in 2003. And that converted FIFRA from a purely regulatory statute where applicants bring applications to EPA to seek registrations, but then it made it a system whereby applicants pay a fee. And depending upon the type of registration that applicant is seeking, the type of regulatory action the applicant is seeking, there are specific fees that are owed and must be paid upfront. And there are timelines that were put in place. So the industry agreed to a system whereby they would pay fees, but in return, EPA was then obligated, and I put that in very large quotation marks, to make a regulatory decision on a particular action within a specific time frame.
Keith, that's really helpful context. And so we've talked about how FIFRA evolved, but for listeners who may not work in this space every day, it raises a broader question. What is FIFRA ultimately trying to accomplish, and what falls under its reach?
So FIFRA is a statute that regulates all of the pesticides, and pesticides is a large class, as the statute is named. It's insecticides, fungicides, rodenticides, it's also herbicides, ascaricides. So that's one thing that the general public, I think, needs to understand, is that pesticides, from a legal standpoint, is the larger term. And then within that, insecticides and fungicides and herbicides, a lot of what we deal with fall into that category. Congress understood that these are by nature designed to kill something, and also that they're the only class of toxic chemicals that we specifically and intentionally just throw out into the environment. So we use them on our food crops, we spray them in the air, for example, spraying for mosquitoes. We treat articles with them if we want to protect those articles from pests, moths, or other things. So there needs to be some kind of review and figure out if there's been any updates to the harm. For a long time, I was told that we really focused on the insecticides as a class because the insecticides, for the most part, are neurotoxic. That's how they work. They are designed to attack the insect's nervous system. And a lot of the original classes of insecticides were modified from chemical warfare agents. It's one thing to be clear, like we are not putting sarin gas on our crops. That is not what's happening, but we are using modifications of those. And the modification idea was that they would be able to kill insects at levels that would be safe for people. And so we all focused on the insecticides for a long time in terms of our human health concerns, as well as wildlife health concerns, mammals, birds, fish. And we sort of didn't worry about the herbicides for too long. And when I say didn't worry, I mean we didn't test for them in food. USDA didn't include them in its food testing residue program. We didn't review the regulations as strictly. We didn't require as many toxicity tests for them because we had this idea that they weren't threatening to the kinds of biological systems that operate in vertebrates. We know now with glyphosate, with atrazine, with others, that that's not the case. And so we are paying more attention to them. I think like where we are now with the application of FIFRA is really understanding the cumulative impact of all these different classes of chemicals and the additional harms that we've learned about over time and how to manage that. And I think the goal of FIFRA, I think when it works well, we are risk trading downwards. So basically move away from the most toxic classes of chemicals and try and replace them with safer, less toxic, or no chemicals. And actually, I would love to have Keith jump in here, especially because of his experience in the biopesticides world, which is so important for coming up with those safer chemicals.
Yeah, thank you, Jennifer. That's an excellent segue. Biopesticides are very broadly defined as biologically based pesticides. These are chemicals that are derived from biological organisms, so from insects or from plants or from microorganisms. You also have microbial pesticides, which are actual microbes that have a pesticidal effect. Now, we have to be careful when we use the term chemical. I mean, chemical applies to basically everything. So when we talk about chemical pesticides versus biopesticides, we're referring to conventional chemical pesticides because, of course, the biopesticides are chemicals also, but they're chemicals that are derived from nature. And Jennifer had mentioned BT, the proteins that are derived from the class of microorganisms that fall under the Bacillus genus, Bacillus thuringiensis. And there's a whole slew of proteins that have very useful pesticidal function, but they are specific to insects and they have absolutely no impact on human beings whatsoever. For many years, BT proteins were one of the few chemical pesticides that was approved for use in organic agriculture. And many members of our population now are becoming more aware of sustainability. And biopesticides really fit into that. And they are really becoming much more prominent in use in agriculture now.
Thank you, Keith and Jennifer, for providing that overview of some of the goals of FIFRA. And as we were kind of discussing, part of this goal is to generally not cause any unreasonable adverse effects on the environment, right? And that's built into the statute. And so, Keith, I wanted to ask you from a legal perspective, how does FIFRA define what unreasonable adverse effects on the environment means?
Yes, very, very important question. And one of the things that really makes a FIFRA practice just infinitely interesting is because, yes, the FIFRA standard is no unreasonable adverse effects to human health or the environment. As we've discussed, pesticides are intended to have adverse effects. But what we want is for the adverse effects to be directed and specific. We want them to have adverse effects to the organisms that we want to control, but not generally. And so the FIFRA standard enacted in 1972 was, all right, so EPA shall register a pesticide if it is determined that it will perform its intended function without unreasonable adverse effects. So what does unreasonable mean? Well, unreasonable adverse effects means any unreasonable risk to man or the environment. And this is the important part, taking into account the economic, social, and environmental costs and benefits of the use of the pesticide. So FIFRA at base is a cost and benefit statute. So EPA has to get into the entire calculation of, so what are the economic benefits? What are the social benefits? What are the environmental costs? And that's why each and every pesticide registration decision is individual to that particular product. And oftentimes what EPA will do, the process as it goes through that PREA process that I talked about earlier, what EPA will do is it will say, okay, so this is the proposed use pattern. We have determined that the economic benefits of this proposed use pattern don't outweigh the potential environmental costs. And therefore, what we're going to require is a different use pattern, or we're going to impose what are called terms and conditions on the product so that it can only be used in certain ways, because if it's used in certain ways, we can make that no unreasonable adverse effects finding. But it's a fascinating exercise in regulatory science and regulatory procedure. Oh, actually, I do want to point out something that's very important, and Jennifer may get to this. So Jennifer, I'm just going to introduce the FFDCA standard, because if you have a pesticide that's used on a food product, then that pesticide is co-regulated, and it doesn't replace the FIFRA standard, but it adds to the FIFRA standard the FFDCA standard of a reasonable certainty of no harm. So any pesticide that is used on a food crop, if there are residues of that pesticide that remain when that food is potentially ingested, then EPA has to determine that there is a reasonable certainty of no harm, which is just a really high standard.
I'll pick up that baton and run with it. So thank you, Keith. That gets us into FFDCA and the Food Quality Protection Act amendments. And it is a higher standard, and it's an additional consideration when pesticides can be exposures to people, including sensitive populations, including pregnant women and children. It is one of the highest standards, reasonable certainty of no harm. It has 3 key provisions that make it strong and that are very influential on pesticide regulations. One, which I think is the least important, is what they call the FQPA tenfold, or the FQPA 10 times. We sometimes just call it the child protection factor. So the idea is that when you extrapolate from, for example, a rodent study, you have data gaps and uncertainties, you have different uncertainty factors, and there's sort of tenfolds for each of those that are traditionally applied to tenfolds, one for extrapolation from animal studies, another one for differences across the population among a human population, tenfold differences in sensitivity. But then there's this third one under FQPA, and that tenfold is for uniquely susceptible populations. And they include primarily pregnant women and children, but also people with different diets that are high eaters. So for example, Arctic populations, seafood and meat eaters that might have high levels of some of the old persistent organic pollutant type pesticides, most of which we've gotten off the market. But more importantly, the game changer of the Food Quality Protection Act was it also required EPA to evaluate pesticides as a cumulative assessment group based on a shared mechanism of toxicity, so that all of the organophosphates were evaluated together initially, all of the carbamates were evaluated together, all of the chloracid analytes like acetochlor were evaluated together, the triazines like atrazine were evaluated together. And looking at that cumulative assessment group, the idea was that you didn't just count the amount that you could be exposed with a reasonable certainty of no harm to each individual. You had to include them as a group. It makes sense. It's sort of like if I hit myself with a small hammer, a large hammer, and a sledgehammer, one after the other, I've got to count. They all have an impact, right? So you needed to account for the aggregate exposure to each pesticide through all the different routes of exposure, including food, water, lawn care, home uses, public health spraying if there is, and in addition, the cumulative assessment group. That was a game changer. We started out with organophosphates, I think something like 56 or 58. They were the first ones to go through FQPA review, and we're now down to about a dozen. So that is an example of moving in the right direction. And the ones that they were replaced with were not as acutely toxic. So not as many farm worker poisonings, not as many fish kills and bird kills, things like that. We still have a dozen left. That is a fail in my mind. EPA has not done a cumulative assessment group for a while, and they've even now disaggregated the organophosphates. So those last 12 I just told you about, EPA is doing them one at a time. They're not looking at them at a cumulative assessment group for the purposes of risk to children or developmental neurotoxicity risk. That's a problem. EPA also did not look at the neonicotinoids. There's about half a dozen of them. They're also neurotoxic insecticides. EPA did not look at them as a cumulative assessment group. So now, instead of controlling how much wine we're going to drink before we get behind a wheel of a car, they're just evaluating the size of each cup separately, as if that's all we're exposed to. This is not a legal problem. This is an application of the law problem in my mind. And I would love to talk about how this impacts getting safer alternatives to the market. How do we make a market space for the biopesticides?
That's a great point of discussion, Jen. And Keith, you've worked both inside and outside EPA. How do you see FIFRA handling that question of safer alternatives without crossing the line? What room does the statute give EPA when it comes to encouraging safer options?
Jen, that's actually a very useful question that you asked, and it allows me to kind of point out that FIFRA in itself started as a statute that was implemented by USDA. Their remit is to support U.S. agriculture, which is incredibly important, maybe one of the most important sectors of our economy. And so, to your point, FIFRA is not intended and it's not implemented in a way that creates winners and losers in the economic sense. What FIFRA is intended to do is to ensure that farmers have as many arrows in their quiver as possible to address the pest pressures that they face in trying to produce the crops that we all rely upon. And so the point of FIFRA is to make sure that each of those arrows in that quiver can be used in a way that won't cause unreasonable adverse effects to human health and the environment, that can be used safely. So at the end of the day, it is for the farmers to decide which of these quivers do I want to use. The important part for EPA under FIFRA is to ensure that every registered pesticide can be used in a manner that is safe and meets the statutory standard. I do think that, yes, the market for biopesticides is increasing. They are becoming more prevalent, but that's not because they are necessarily being promoted. It's because that growers are deciding on their own that they want to use these other additional tools that they have. EPA has a very critical and crucial role. Of course, I was at EPA for 16 years, and that causes no bias whatsoever, in my opinion, when I say that some of the most preeminent, top-notch, dedicated, and effective scientists that really do the work of ensuring that pesticides can be used in a safe manner reside at EPA.
I agree with you that FIFRA is not there to promote one chemical or class of chemicals over another. It's not their job. They don't pick winners and losers, but they should. And they should make a place for the safer chemicals, and they should do it by elevating them on the website. But my question to you is, don't you think that the cost benefit analysis should do that? Like, if EPA was doing a proper evaluation of the costs and benefits, shouldn't the safer chemicals come out better and get a better cost benefit analysis and be promoted that way?
Yeah, that's a very intriguing and nuanced question. What I would say to the first statement that you believe that EPA should, in fact, pick winners, I'm really glad you pointed that out because that enables me to point out that EPA operates under a specific statutory mandate. EPA can only do what FIFRA allows it to do. EPA can't do what FIFRA doesn't allow it to do. And so FIFRA does not allow EPA to pick winners because if you end up as one of those losers, then you can take EPA to court. Now, whether or not EPA should factor that into its economic analysis, its benefit analysis, that's an intriguing question. I don't have an answer to that question, but as I think about it, it strikes me that that could be possible. But if I were legal counsel to EPA, I would say for you to do that, you would have to revise your regulations because the regulations currently don't say that that's what you do. And so you would then have to go through a notice and comment process and tell the regulated community, along with the public in general, this is how we're going to operate from this point on.
So there are some real guardrails around how far EPA can go without changing the rules themselves. And against that backdrop, what are some of the other major provisions in FIFRA that shape how pesticides are regulated?
Some of the other provisions of FIFRA, part of the amendments to the statute required that the registration for a pesticide be re-reviewed every 15 years. And the analogy that I use is that pesticides used to be like lawyers. You pass the bar once, and then you're a member of the bar until you die. That could be 90 years from then. Doctors, on the other hand, if you're a board certified physician, you've got to take your boards regularly. And so pesticides used to be like lawyers. You get a registration, that registration lasts forever. But now with the amendments, they're more like doctors. You have to go back every 15 years, and EPA has to reevaluate and determine that the data, science, and information that supports that pesticide registration meets the standards of today.
Yeah, that gives us a good sense of how products are evaluated over time. And we've touched a bit on this already, but let's make it explicit for listeners trying to keep track of the players here. What agency is responsible for implementing FIFRA, and where do other agencies fit in?
For the most part, is solely implemented by EPA. FDA has a role under the FFDCA for enforcement of residue standards on food. If EPA has established that residues of a particular pesticide can be on food at a ceiling that there can't exceed a certain concentration, then FDA has the authority to enforce those standards. EPA doesn't regulate pesticides in a vacuum. It works with USDA. USDA has many experts in terms of how pesticides may be useful to growers right there on the ground. So EPA and USDA certainly talk and keep each other apprised of what's going on. But from the standpoint of just the implementation of the act, it's primarily EPA.
Thanks, Keith. That should be really helpful for our listeners. And with that institutional picture in mind, could you walk us through what the pesticide registration process actually looks like from the legal side? And Jennifer, feel free to jump in as we go.
Yeah, I'll give a very, very high level overview. And then Jennifer has substantial experience working kind of in the nitty gritty of different registration decisions. But from a very high level, a pesticide applicant will submit a registration application to EPA, the Office of Pesticide Programs, and then depending upon the type of pesticide that it is it a conventional chemical pesticide? If it's a conventional chemical pesticide, it's the responsibility of the registration division. There are other divisions that assist the registration division. There's HED, which will look at the potential health effects. There's also EFID. What are the environmental effects that it might have? And then there's BEAD, the biological and economics effects division. So BEAD will look at the economic impacts of the pesticide. Now, if you're a biological pesticide, you go into BPPD, the Biopesticides Pollution Prevention Division, and BPPD will do the most of that registration work on its own. So there are branches in BPPD that will do the human health assessment and the environmental effects assessment. And then if you're an antimicrobial, so if you are a disinfectant, you go into the antimicrobials division. And antimicrobials is also a standalone division that will do the human health effects and potential environmental effects. Once you kind of get run through that gauntlet, which can take a number of years, can be very expensive and time consuming, then EPA will register the pesticide, and depending upon specific terms and conditions that are placed on that registration, the registrant can then distribute it in accordance with those terms and conditions.
Yeah, that was a great summary of the process. I will say, though, that the process on paper, it is both too slow for the registrants, and there are too many harmful uses of chemicals that get through. And we know that because we have reported fish kills, and we have reported poisonings, and we have farm worker poisonings. I do think that on both sides, the pesticide manufacturers whose products are moving too slow and the people out in the field who are being exposed unsafely are unhappy with the process. There could be a lot to address that with label enforcement, and there's been some retired EPA people that have written about that.
Yeah, I'm glad you mentioned that because I wanted to follow up on your examples because it's really premised on the label. It is a violation of federal law to use a pesticide in a manner that's inconsistent with its label instructions. I'm not aware of any other product that's in commerce where that is necessarily the case. And the reason for that is because, again, pesticides have to be used in very specific manners for them to be safe, for them to not cause unreasonable adverse effects. And so the question I would have for Jen is, yes, obviously it's a matter of fact that there are adverse effects that happen. There are fish kills, there are other environmental effects, there are bird poisonings and that sort of thing. And there can be poisonings of farm workers. But it strikes me that in many of these cases, it's because the pesticide isn't used in a manner that's consistent with the label. It's a result of the label not being followed. And that is a huge concern. And I agree 100% that I do think one of the things that, in terms of pesticide regulation, that we don't do a good enough job in is just really insisting to people you have to follow the label. And I'll just use one example. Saturday morning in the front yard doing yard work, neighbor down the street, go down and talk to him. He's spreading glyphosate. And I look at the glyphosate. Well, it's 10x concentrated and he's spreading it. I said, you're supposed to dilute that. He said, oh, yeah, but it works better this way. Okay, yeah, obviously it does. If it's 10x, it will work better, but that's not how it's supposed to be used.
Yeah, so that is a huge problem, and I agree, and I would love to work to help do something about that. I also point out that we don't know that that's all of them, and that some of them it isn't, and that in a lot of cases, the label doesn't work. I published an article, I think in 2024, where I looked at all the EPA's pesticide poisoning data for the neonics, which are supposed to be safe for humans, and there's like 800 poisoning cases over 5 years. And those are the ones that got to EPA and that EPA had reviewed and culled and listed. That's a lot. Some of them were severe, like seizures, chemical poisonings on skin. One of the areas just to pop up is farm workers. So farm workers don't have a lot of say in whether the label's enforced or not. They've got to go out and do the job. And they're at the front line of getting hurt by that. And another big area, Keith, as you point out, is homeowners' uses. Homeowners are notoriously more concerned with the pest problem than reading the label. And I totally get that. So, yeah, I mean, I think there is a problem with enforcement, and that's a problem right now because the Trump administration, it's fast-tracking product approvals and cutting enforcement across the agency. But in addition, I don't want to blame the user in all cases. A lot of times it can't be helped, and a lot of times we don't have any evidence that the label was misused. There's some of the poisonings I looked at were people that lived in apartment buildings. There was one that was an elderly person. She didn't have a lot of mobility. The apartment got sprayed. They told people they had to leave for a certain amount of time. She was sitting out in a wheelchair in the sidewalk. So she went in, I think, before that time was up. But, she can't stay for 18 hours sitting in her wheelchair on the sidewalk. So that's impractical. And that goes again to why can't we use least toxic alternatives? Why can't we use safer products? Why can't we have a cost-benefit analysis that takes into account all of this stuff when it's doing a cost-benefit review?
And I think that really underscores what's at stake when things go wrong, whether it's misuse, gaps in enforcement, or situations where the label just isn't workable. Keith, what kind of penalties can actors face when they fail to comply with FIFRA's requirements?
The penalties can be substantial and significant. There's one case where a well-known company was producing an appliance, and the appliance was advertised as having a particular chemical substance that enabled the appliance to have a disinfectant or sanitizing effect. And they had not gotten EPA approval for that. Subsequently, were fined up to $8 million for sale and distribution of that product. And so FIFRA does have very strong enforcement provisions, and in some cases, they have resulted in significant fines.
Thanks, Keith. And before we wrap up, I want to shift gears a bit. We've covered the core structure of FIFRA, how it works, where it falls short, and how it's enforced. As we look ahead, are there any emerging issues or trends you think listeners should be paying attention to?
Sure. So where things are going is that EPA career staff are being pushed to do faster reviews. We know that. There's been articles in major press saying this is the goal of the Trump administration. EPA is to get rid of the backlog of pesticides and chemicals as well in the new chemical review under TSCA. So they want to speed that up. They're saying they're going to use a lot more AI, artificial intelligence, to review comments and things like that. To me, that makes sense. It's a good use of it. They're also going to cut requirements for toxicity testing down to essentially what's called NAMs, the new alternative methods. They're basically cell-based assays coupled with computer modeling programs in order to do quick, fast tests of predictive toxicology. The use of these new tests, EPA has no method or guidelines for using them. There's nothing in writing, and there's nothing that's been shared with the public. In addition, EPA doesn't have guidelines for integrating that information with existing information. So what the pesticide office has been doing is using NAMs instead of existing information. Their first run out of the gate has been for organophosphates, 3 of them, acephate, dimethoate, and malathione. 3 chemicals that we don't need to know anything more about. I mean, we've known about these chemicals for 50 years, and they have a plethora of scientific data. Nonetheless, this week in court, EPA lawyers said that they were waiting for additional NAMs data. With the excuse of that, EPA is missing the deadlines to finalize its evaluation of those. So I don't think this is really an example of being more efficient while continuing to adhere to its statutory requirements to protect the public. I think it's focusing on the fast-tracking approval. It's reducing the amount of scientific information that will be available to reviewers, to agency staff for each one. It's moving it out of the public eye. And I also think skipping over practices of having written guidelines for how to implement something and having public comment periods and things like that.
What I would focus on from my perspective is that EPA OPP is severely understaffed. And at the same time, they're tasked with registering new products. As Jennifer has pointed out, they're tasked with evaluating old products. They're being asked to do more. And it's really, I think, a disservice not only to EPA, but also to the American people that OPP is not more fully staffed than it is, because they are the bulwark to ensuring that the FIFRA standards are maintained for products that are absolutely necessary. We cannot feed the population that we have either in this country or globally without the use of pesticides.
Thank you, Keith and Jen. And can you maybe tell us a little bit more about how some court cases have shaped the law? And I'm also really interested in hearing more about the primacy question here with respect to FIFRA. What role can state or local governments play beyond what is mandated?
Yeah, those are two very good questions, and they are related. So let me start with the primacy question first. States do have regulatory authority to regulate pesticides. What a state cannot do is allow a use of a pesticide or sales of a pesticide that are prohibited under federal law. Now, having said that, states do have authority to regulate use of pesticides within their territories consistent with federal law. So a state may impose additional requirements for use of a pesticide if it determines that's appropriate in the context of that particular state. They can be more restrictive, they can be less restrictive. Now, with respect to the cases, there's a very critical set of cases that have been in the federal and state judiciary for many years surrounding glyphosate and whether or not glyphosate has resulted in specific adverse effects to people exposed to it. There have been a number of judgments that have been rendered against the manufacturer of glyphosate. Roundup is the common name for people who don't know glyphosate. So there's been some tension there because some of the cases have said the manufacturer did not warn of specific potential harms to use of glyphosate on the label. And the manufacturer has pushed back and said, yeah, but the label is approved by EPA. We can't put something on the label that's not approved by EPA. And there's tension there. And there's a case that is the Supreme Court just asked the Solicitor General to weigh in on that question. So this is a question that may very well get resolved at the Supreme Court. Does FIFRA preemption and EPA control of the label, is it basically absolute, such that a state can't say, or a court can't say to a manufacturer that you should have X on your label and we're holding you responsible for it, when in fact that FIFRA label must be approved by EPA?
Thank you, Keith. Thank you both so much for joining me today. It's been a really great pleasure to speak with you, and it was a really interesting conversation.
I've enjoyed this. I really enjoyed the back and forth with Jen. She and I, our careers have really overlapped. We've both been doing this for a long time. So I appreciated this opportunity. If there are any listeners who want to know more about the legal, procedural, regulatory aspects of FIFRA, please feel free to give me a call. My law firm is www.bioaglaw.com.
Yeah, it was really fun. Thank you. I really enjoyed it.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.